the case in 1987. At that time, I had short hair, businessman, working for IBM. I was a financial planner. And there were some problems going on at the motel, and one of the problems was that the manager that had been there had left, partially because the fence had gone up and partially because of the uncertainty of the business. And so I took a leave of absence, and I came to Montauk, and I dealt exclusively with the lawsuit, attempting to get it moving and see what it involved. And at that time, there was a motion by Mr. Biazzi to dismiss the complaint, to dismiss the action, because the Breakers Motel and the other plaintiffs had failed to bring in all Montauk property owners in asserting their claim. And the court found that that wasn't necessary because the Breakers Motel and others were not asserting any rights adverse to the other property owners. And then it went on, and I was gone. I went back to IBM. I was gone for 3 years, and then I came back in 1990. And in my absence, there were all kinds of things going on. There were subdivision plans being drawn by the lawyers for the property. The Hither Woods deal had just closed for $17.1 million, and with the same lawyers involved. And so the whole thing had just been a mess because there was no one watching over the lawsuit. So I ended up dismissing the lawyer that I'd hired in 1987 and brought on, and then I brought on a third lawyer. That's the third one that we had. And I began to move the case for summary judgment. And it went very well. And as a result of that action, I discovered a lot of things. And I became more familiar with the rights. And before the ruling came out, I acted to incorporate the Montauk Friends of Olmsted Parks as a corporation of the community to come together and take control of these lands and put them to our most beneficial use. And when I did that, which I was hesitant to do because of the responsibility involved in starting a corporation. You start a corporation and you take on executive powers, and you have to be responsible to making sure that the executive powers are honored. Yeah, you can't just do it and then walk away from it because it's not good for the community. It doesn't fulfill your responsibility either personally or legally. So that's why I'm here today, and I hope people respect that. I'm not doing this for me. I'm not doing this because I like to do this. I'm doing this because it's something beautiful for the community, and I'm doing it for you. So in February of 1994, we got a ruling out of the New York State Supreme Court in Riverhead. It's a ruling in summary judgment. It was written by William Underwood Jr., William L. Underwood Jr. He's a phenomenal judge. I mean, beautiful decision, very comprehensive. It covers 23 pages, double-spaced, and he goes into all the arguments. And I don't really need to read much of this to you. The important thing to understand is that this is a summary judgment. And a summary judgment means that there was no dispute on the facts. There was no need for a trial. The facts and the law were all very clear on this issue. And so that we had a summary judgment. And basically, I think some of you are familiar with the language at the end of it in the order. The order says that the court directs that judgment be entered in favor of the plaintiffs and against the defendants. The defendant's property is burdened with the covenant described herein, and are without the right to erect fences, berms, or other structures on the reservations described therein, and are forever barred from making claim to erect such structures. 5 minutes. So this is beautiful. This is a beautiful thing. And it also says here, the defendants are directed to remove any and all fences and structures and restore the said reservations to their original open and natural state forthwith. Defendants and their employees or agents are further directed to forbear from preventing plaintiffs from enjoying their common use of said reservations. This says plaintiffs, but it's not just the plaintiffs. These are community properties. These are our properties. And we have 200 acres of properties, and we have many miles of roadways that are ours. They're our communities. So we need to understand that. And I hope that people will show up on Wednesday and look at the maps and ask me questions and see what I propose that we do to take control of our rights. Okay, the Second Judicial Department in Brooklyn, in an order dated February 22nd of this year, okay, issued an order, and that order said that unanimous decision, 4 judges, appellate division, okay, unanimous, that the only modification to the lower court order was that one of the plaintiffs had sold his land, and if you sell your land, you don't have the same enjoyment of the rights. You've alienated yourself from the rights. And also that there was a negative easement. This is an easement that burdens the property and prevents the man that holds the fee or the corporation that holds the fee from being able to do anything with what they want from it. Okay, so that was the appellate division, and then on September 10th of this month, the appellate division, the Court of Appeals, the state's highest court, denied Mr. Biasi's final appeal. I'm going to have to sum up here. Something to understand is that now it's up to us. Well, it's up to us. It's up to the community. And I hope everybody will understand that what I've attempted to do is bring out and enable, if you will, all of our individual and corporate rights in Montauk. We have the power to assert them. We should assert them. We do require some judicial review because it's going to be a chicken fight for a little while, because the town, the county, and the state are not going to want to give up their rights over these lands. And we have other lands that are still in private title, which we're going to need some review over. I will tell you, though, that I've discovered some other things, that the Dongan patent, which covers Montauk, which we have the right to assert our rights through, is actually protected by Section 17 of Article 1 of the Constitution of the State of New York. And we also have an enabling act out of Albany from at Chapter 139 of the Laws of 1852. As far as the law goes, I don't see how we can walk away with nothing. At the least we have our Benson reservations, and at the most we have just fantastic ability to really protect Montauk and keep it and make it the kind of place we want it to be, and to keep it from going the way of Coney Island or these other overdeveloped areas. We have that ability, but we have to come together, people, and that's why I'm here tonight. I hope you'll come in to the meeting. That's at Third House at 7 o'clock every Wednesday for the rest of this month. Okay, I'll be there to answer questions. Please come and visit me. Thank you.